Good afternoon from the Bay Area. My name is Jason Putnam Gordon. I'm with Polsinelli, and you're here because of Idea to IPO. Today, we're going to talk about how to relocate an international startup to Silicon Valley. It's a great topic. Before we begin today, I'm going to share with you sort of an overview of how things will go. First, please note that you are or the webinar itself is being recorded. So the good news is if you miss some or all of it, that you'll be able to catch it later, because so long as you've registered, you will be able to send you an email with recording later. And we'll do that about a week or so after the event. Second, if you've got questions, that's terrific. I'm gonna speak for about an hour. I'll try and take some questions as we move through it. If you've got those questions, please use the Q&A function. It's easier for me to track and manage because otherwise, I'm not only presenting today, but also running the tech in the background. So it's quite a lot to track. And as I mentioned, I'll speak for about an hour, and then we'll move on to a half hour of questions and answers. Now, one of the things that's also helpful before we really kind of get underway is if you take a moment or two and fill out the audience survey poll. It'd be great to see who's in the room. Help me sort of tailor today's conversation towards that. So without further ado, as I mentioned, you're here to learn about how to relocate an international startup to Silicon Valley. You're here at Idea to IPO. I'm Jason Putnam Gordon with Polsinelli. I'm a venture capital and emerging growth company attorney. I'm located in the San Francisco Bay Area. My office is in San Francisco. I'm in the East Bay these days with the pandemic, at least for now. Now, with that in mind, let me give you a little bit of a sort of caveat that any lawyer, I think, probably would. You know, today's discussion is general information. It's not legal advice. There will be facts and circumstances that, you know, whether you present it in the Q&A or even if we have a follow-up discussion afterwards, probably won't be enough to really sort of elicit sufficient information from you to give you, you know, actionable legal advice. We'll talk about how things typically get handled, but that may or may not apply in your case. So the sort of corollary to that is you need to retain competent legal counsel who practices in this space to give you input. All right, so in terms of the structure of today's call, we're going to go over my background. I'll tell you a little bit about who's in the room today. We'll then, what I really like to do is sort of zoom out and provide a big picture so that folks can understand where we're heading and where we're going, and also whether or not it makes sense, or give a sense for whether or not it makes sense for today's discussion to apply to their particular situation. Again, not specific advice to them, but just the framework of how we determine whether or not you know, makes sense to relocate and or what the sort of corporate setup looks like. We'll then talk about sort of the corporate structures that we typically see, you know, for companies that intend to be or already are venture-backed. And we'll talk about some of the tax issues that generally come up. We'll talk about IP issues and intercompany agreements. Those are relationships between, you know, maybe it's a foreign parent and a US subsidiary, or maybe you end up flipping and having a US parent here. And you know, we'll move on to some immigration and employment laws. Now, let me also say, you know, I've given you probably twice, this will be the third time, sort of my warning that what I talk to you about today is not going to be legal advice for your situation. The other thing to note is, as I mentioned, I'm a venture capital and emerging growth company attorney. So that's really my area of focus and expertise. What does that mean? That means I work with companies as they form, with the financings, and when they exit, and serve as their outside general counsel. A lot of today's conversation is going to, you know, really be sort of based on how I typically work a project of relocating a company here, right? So we bring in and utilize other specialists, right? Immigration specialists, tax specialists, employment specialists, those types of things. So, you know, I'm not going to know, or I wouldn't even want to try to know all of those various specialties. No one person can. That's why we have specialists. Now, a little bit about Polsinelli. Polsinelli is an AmLaw 100 firm. with approximately 900 attorneys in, I think, more than 20 offices in the US at this point. We keep opening them. It's very exciting. As I mentioned before, my office is in San Francisco, but I do work with companies throughout the US and the world. You may ask, well, like, why is that? And the answer typically is California is a very big market. Certainly, if you're talking about venture and tech, the SF Bay Area is, one of the main focal points in the world, if not the main. And so a lot of companies that are in tech or venture-backed have some sort of foothold or toehold here. And I love working with entrepreneurs on financing and as outside general counsel. Love working with executives. And I'm about to sneeze. Ooh, sorry about that. I also work with VCs as they deploy capital, or angels too. That's kind of my niche. Let's talk about big picture stuff, because I think it's very important. We're focused here today, or my conversation with you is focused on venture and venture-backed companies. So there's a particular model that venture sort of follows. Now, not every single company that ends up being venture-backed falls into this, but this is sort of the way that it's generally done. So if you look, there's generally a startup financing cycle. And initially, when the initial team is getting put together and the initial sort of prototypes are being built, and maybe even as you're starting to get some market traction, that's in the sort of seed capital stage. And, once an entrepreneur, and it depends a little bit on the sort of sectors versus, life sciences versus SaaS or consumer product companies. But sort of by and large, when we're thinking and talking about this, once there is some traction in the market, you've been able to demonstrate that product market fit. And, that's usually when the sort of tried and true VCs are really out there looking to deploy their capital into your company. And that's in large measure because, VCs are fiduciaries to their investors, right? And they've got a fund. That fund has investors in it. There needs to be a return. That return, and we can talk about this at some other point in time, but generally needs to be made within 7 years. So the VCs have a typical strategy for a traditional venture capitalist is, deploy some capital now. Well, basically get a return over 7 years, deploy some capital now in a portfolio of companies, see which ones are going to be successful, deploy additional capital into those and make their returns off of those big winners, understanding that that's really where the bulk of the returns are going to come from. The bulk of the returns do not come from companies that are doing okay, and they also acknowledge, there are a lot of companies that are not going to be successful, especially in those sort of early stage bets. So, what we see is capital getting sort of wired, documented into the company. Ideas go into the company. Folks are bringing technical skills, sales, marketing, whatnot. When you do that, you add some capital, you add some time, you add a whole lot of hard work, bit of luck, and hopefully the company increases in value. That's sort of the big picture there. And with that in mind, this sort of, I guess maybe I'll see if there are any questions first. And if there are, please use the Q&A function. And let me also just put my, if you want to connect with me, feel free to connect with me on LinkedIn. So let me just kind of put that there. I'm Jason Putnam Gordon on LinkedIn, and jgordon@Polsinelli is my email address. Great. Okay. We've got one question, which we'll probably be able to knock out now. So we got a question that says, sounds like you work with both sides, both investors and companies. What type of company do VCs typically invest in? And so let me answer that first and foremost. So again, when we're talking about traditional VC funds as opposed to strategic venture funds, that's maybe funded by a large company or something like that. We're talking about traditional venture fund. They've got a set of investors. They're set up as a limited partnership. So that's a pass-through entity. If they invested in pass-through entities like an LLC here in the United States, that's a limited liability company. There'd be kind of a nightmare from a tax and accounting perspective insofar as the profits and losses of all those portfolio companies would get passed on to their investors sort of in real time. So that sets up the sort of decision that usually here in the US, it's going to be, and by usually I mean an overwhelming majority, a C Corp structure. As for the state of incorporation, I would say in the last 10 to 15 years, especially here in the Bay Area, it's going to be a Delaware C Corp for the type, for the location or the domicile of the company. The reason for that is really that they're kind of a few fold. Delaware law has developed to be very supportive and friendly for business. So there are additional protections for the directors and officers. Usually VCs are going to want to take a board seat, so they'll want to have the liability protection for their appointee or their designee. Additionally, there are some sort of mechanical benefits for the investors if and when there comes a time when a corporate transaction needs to get done, which sort of beyond the scope of this. Additionally, Delaware's got the Chancery, which is a court that's very sophisticated and focused on business issues, which is helpful to the extent there's a dispute that's related to the company. You're going to end up in front of a judge that knows what he or she is doing with respect to it and can move it quickly, which is also a huge component of that. Delaware Secretary of State's office also processes documents very quickly and efficiency, which if you're trying to get a deal done is super critical. There are a few other reasons, but that's usually why it ends up being a Delaware C Corp, at least if you're forming out here in the Bay Area. And with that in mind, kind of moves on to the slide. Balancing several factors. So whenever we're thinking about choosing a corporate form, we do think about a few different things. First and foremost, business reasons usually drive the decision. And as I just sort of articulated, what usually drives it on the business side here is the investors. They want a Delaware C Corp out, at least out of the Bay Area. Tax issues, we just talked a little bit about sort of the mechanics there. Fundraising concerns, again, just talked about that. Intellectual property concerns. Here in the US, and we're going to talk about IP later, you want all the IP to reside in an entity, and or you want it to be flowing back and forth, within the corporate structure properly, because that's just going to create certainty. That way, if and when there's time to either do an IPO or to get acquired or do something along those lines, there's a clear chain of title and not uncertainty, which can sometimes, ripen into a lawsuit, which is terrible. And you also want to make sure that goods and services are being properly sort of moved through the corporate organizational structure. And we'll talk a little bit about that. That's sort of where the intercompany agreements come in with respect to all of those. Now, common options here, theoretically, one could just come to the United States with their entity that they have and just start doing business. One of the issues that sort of comes up, well, there are a couple of issues that come up, but among them are a few facts, right? There's all of a sudden then that entity itself is being subjected to US tax, which it may or may not want to do. Many times companies want to have a US company actually be the entity that hires employees here in the US so that there's a shield, a liability. I mean, that's one of the ways, forming an entity is one of the ways you kind of get a liability shield put in place between, the foreign parent and the US sub, if that's the way that you're structuring it, or sort of vice versa. Another thing that comes up from a sort of sales side oftentimes is that customers of these companies want to do business with a US corporation or a US entity. And so that's what drives the decision to form a US entity. Now, the sort of structure is typically kind of one of two ways. If this had been a few years ago, it would almost always be sort of, you do a flip in the US parent, or it'd be like a parent would be US, especially if you're raising from US investors. I think the last 5 to 10 years, and then especially through COVID, a lot of that has sort of changed. The world's become a lot flatter in terms of where capital moves and where folks get comfortable. So not unusual to have US investors investing in overseas companies, or companies that are abroad. It really does depend on the jurisdiction. Okay, so there are some jurisdictions where folks feel very comfortable, culturally, legally, etc. And if you're outside of one of those, it's very, very common to sort of end up doing a flip, so that you would end up having a US parent and then a foreign subsidiary. And the US parent would receive all the intellectual property, license it back to the sub, and the investment will go into the US parent. One thing that I always advise against, and I sort of see it all the time when you've got founders who are sort of bootstrapping, is sort of having a common shareholders of affiliate companies. And what I mean is, the founders will set up a company in I don't know, somewhere in the EU, right? Because that's where they live, somewhere in there, one of those countries. And then they will set up a US company, and they will be the owners of each. That is, the founders themselves individually will be the owners of each. And that structure is usually not, that will need to be fixed before investment will come in. And the reason for that is, especially when you're thinking about VC investors, let's take a step back, or a couple slides back, to when I was talking about how, they've got a 7-year investment horizon. They want to put their money in, they want to get the return within 7 years. And what that means is everything needs to be very buttoned up and in a form that the company can be sold easily and quickly without a lot of wrangling, without a lot of lawsuits. And so, if you've got a situation where you've got uncertainty with where the IP is residing, with who's got ownership, where control is, you got problems. And so again, sort of setting up a parent sub relationship, documenting it, and then having intercompany agreements governing that, including things like IP and tax and services. That's what we see. That's what the investors are going to drive that. Okay, so let me see if I can answer a couple of questions first. So someone's asking about the Pandora Papers and, different states, the perception of different states' laws. I don't think so. I think, again, the VCs have sort of resoundingly decided they like Delaware corporations. That's what's going to happen typically before the company goes public. So I think there will continue to be a huge drive for that. Would investors be comfortable investing in an LLC? We have an LLC and the product ready for an early stage revenue model. So today's conversation is focused primarily on how to relocate international startups. We typically don't advise international startups to set up an LLC, because that's, again, a pass-through entity, so that the owners of the LLC are going to end up probably, subjecting themselves to US tax. Do investors invest in LLCs? Not really venture capital investors. You might get some angels who will do that. And then separate question, will there be a recording link sent later? Yes, if you've registered, you'll get it about a week or so afterwards. Let's see. If your offices and facilities are located in California, do they still need to register in California? Would they still be subject to California law? Great question. Yeah. So look, if you're doing business in California, whether you are, an overseas company and you don't have sort of California, or excuse me, a US entity set up, or, you are a Delaware corporation and the company is doing business in California. If you're doing business in California, whatever entity is doing the business needs to register, and it's called qualifying as a foreign corporation doing business in California. And that's not just true of California; it's true of many other states. So, doing business in Missouri, got to register there. It's not a big deal. It's not very hard. So let's talk about tax issues. So one of the things in sort of the pitfalls, especially if you've got a situation where, I don't know, maybe you've kind of bootstrapped and you've done it all on your own, where you've got a couple of founders who are set up separate affiliate entities in different jurisdictions, is when you structure the US corporation, you want to pay attention to making sure, or if you can, making sure it's not a taxable event. So that's entirely possible, but we work with tax counsel on that to make sure that it would qualify for basically a tax-free reorg. And usually, as I've sort of alluded to earlier, you want to have a structure so that the foreign entity or corporation is not subject to US tax. Otherwise, there's going to be withholding issues and all kinds of other things along those lines, which are going to make it vexing. Now, one of the things to also really pay attention to, and I alluded to it earlier when somebody asked a question about LLCs, are, if you've got US employees, especially officers, whether or not those folks are going to be subject to US tax. The answer is probably, if they're officers, they're probably considered employees, and so they will likely be considered for US tax. If they're directors, they never come to the US, or they come on a very limited basis. It's quite possible they wouldn't be subjecting themselves to US tax. But what does that really mean? Why do we care? Well, I mean, that means if you're subjecting yourself to US tax, that means you need to get, a taxpayer ID number, and you're going to need to be paying tax on the income that you receive based on your work here in the US. And so, it's extra tax return, extra hassle for those folks. So just be mindful of whether or not you've triggered the requirements is important. Another real issue that comes up in kind of in the earlier stage when there's no revenue being generated is, doesn't really ripen at that point. It only sort of ripens later, but transfer pricing. And transfer pricing is a concept to ensure that corporate entities are not being used to sort of fraudulently avoid taxes via providing goods and services not being rendered at fair market value. So to try and break that down a bit, the issue is if you sort of artificially were to, okay, so let's talk about, you've got an international company that produces a good, sells it to its US subsidiary that then turns around and sells it to a customer out here. Arguably, if the sort of overseas parents were artificially charging more than what would be the sort of fair market value or fair market price for that good to the US entity, it would be sort of arguably extracting profit from the US without paying, or be extracting income from the US without paying proper taxes on it. So, that's one of the issues that comes up there. The same thing is true for services and those types of things. So it's important. It's an important concept, as the company gets farther along and there's more at stake. Many times the sort of best practice is to bring in an accounting firm to sort of help establish what the fair market value is on the goods or services, so that, you can take a defensible position that you shouldn't have to pay, more tax here or somewhere else. One of the other issues that's really, really important, especially like if you've got, if you've got basically a foreign controlled company, there are special tax filing issues that have to go on in the US. So you want to make sure, you don't just go to any old CPA to get it done. You got to go to somebody who's got expertise working with the companies that are owned by foreigners, non-US citizens, or right. So that's pretty important. Someone's asking me an IP question, which I'm not following. So we'll either take that question later, or we can set up a time to talk about it. And with that in mind, I'm going to move on to the next slide, unless anyone has any other questions. And I'm going to take a drink. All right. So types of IP in the United States. There are a couple other sort of subcategories, but it basically breaks down into like these 4 buckets. There are patents, there are trademarks, there are copyrights, and there are trade secrets. So patents are inventions. They're either sort of processes or items that you invent or create, or they can also be design elements that you've got that you can exclude others from using or making. And obviously patents are terrific. They give you, a government license monopoly for a certain period of time. Trademarks are marks that designate the origin of a good or a service. They can include logos. They can include even trade dress, which is sort of the way that the product is packaged and sold. It doesn't have to be just visual. It could even be sounds associated with it. But, it's all about marking or designating kind of where a product or a service is coming from. Copyrights are, sort of original works of authorship. They cover quite a lot, from software code to books, that are written, and website copy is something that's typically on there, and they can be registered, or they don't have to be registered. You would still get rights to them, although not necessarily the full basket of rights. And same thing with trademarks, actually. We can kind of go into a little bit more about that later. But trade secrets are sort of the last catch-all bucket. So that is information that is proprietary. That means you own it. It is confidential, which means that other folks don't know it, and it's got economic value. And you have to protect these trade secrets. And it provided that you do, like, they last indefinitely. Trademarks can also last indefinitely, so long as you're continuing to provide the good or service in the stream of commerce. Copyrights also last for quite a long time. Quite a long time. I mean, maybe not as long as trade secrets, but I believe it's now up over 100 years or something along those lines. So what you want to do is you want to identify and protect your IP. And then you want to make sure that the IP is actually flowing properly between the entities, right? So kind of what happens here is it ultimately needs to reside somewhere. And if you've got the development going on in the overseas corporation, but it's the US parent, typically you want the development work going up to, you want the parent to license IP into the overseas entity. And then in return, among other things, the parent will get back the derivative work. Now, maybe the overseas entity also does sales, right? And so perhaps the overseas entity also has a right to license that to its customers. But you ultimately kind of want it flow in all together. So, we'll talk a little bit about intercompany agreements in a bit, but that's kind of the general sense for it. And one of the other things that I think, especially if you're going to have an international global company, is branding. So, hopefully you're going to, develop customers, and you're going to you want your product to the extent possible, or your service to the extent possible, to have a uniform theme, so that a customer who sees your product or service in another company, right, or in another country, can identify with it, right? So, companies that have had great success in doing that, Coca-Cola, McDonald's, think about that, right? I mean, you walk anywhere in the world and you see one of those, in the in the country, in a different country, and a can of Coke is a can of Coke because of the trade dress, the way that it looks, obviously the way it tastes, which is a trade secret. And so you need to be cognizant, especially if there's a real target market that you have and you want to hit, that is my branding going to work across the scope of where I'm marketing, right? So the sort of hallmark or paragon of an example is, Chevy in the 70s developed a car which it called the Nova, which here in the US probably refers to a really bright star, but in Latin American countries and Spanish speaking countries, Nova means no go, it doesn't go. So obviously that doesn't work. You don't want to do that. I've got a question about a knowledge process or other thing that does not materialize into patent or trademark, but it does have economic value and can be monetized. So if it's a process that's not secret and not a trade secret, it wouldn't fall into these buckets, but I question whether or not it really isn't one of those things. And should the company make the effort to clearly identify those things and report them to the appropriate tax jurisdiction? So usually, you want all the IP residing in connection with positioning yourselves for a sale. Kind of among other things, that's about being able to take a position upon a sale about what your tax bill is going to be, right? Where those assets are, whether they're, what the tax basis is going to be on that, which affects ultimately what the, tax payment that's going to have to be. So you definitely want to make sure they reside clearly in some place so you can sort of figure out which taxing authority you have to pay. Moving on, IP to intercompany agreements. Intercompany agreements are the means by which the answers to the foregoing issues are documented, right? So, we've talked about this, right? We've talked about goods and services to be provided. So let me kind of make that a little bit more concrete. So many times with these types of startups, right, you've got development work going on in one place, right? That is people working on the IP, people working on the code, or manufacturing going on sort of in one place. And then you're going to be moving those goods or services somewhere. So again, the intercompany agreement provides, the economic terms. It may provide for some of the logistics, although normally it doesn't drill down quite as much on that, as it needs to be flexible, and you're probably using third parties to move some of this stuff around. It provides for the assignment and licenses, right? We've already talked about that. It deals with the treatment of derivative work. So if you're generating a new, you're building on code that already pre-existed, just making sure that derivative work ends up residing in the jurisdiction that you want everything to work in. And it provides for compensation for all of that, right? So if there's development work in the company, so let's talk about that for a second, make it a little bit more concrete. Let's say you got, at this point, you've decided it makes sense to have a US parent, right? But the development work is still going to go on in the non-US jurisdiction. In that instance, the US parent probably raised capital and it wants to get, funds into the non-US entity. And in large measure because it's got a development team that it needs to pay. Well, that's what it's one of the things the intercompany agreement helps to solve, right? So the US parent pays the non-US entity a certain amount of money to develop the IP. And once that IP gets developed, the rights of that IP flow back into the US entity. That's what they get. That's the exchange. We talked a little bit about intercompany agreements before, and also the need, as the company gets further and further along, they'll need to get more sophisticated, more robust, and eventually it might be, time to do a transfer pricing study. So let me see if there are any other questions on that before I move on just to intercompany agreements. Nope. Immigration issues. Well, this is something that is important to consider. Before you come to the US, if you're not a US citizen or permanent resident, well, if you're a permanent resident, I guess you already sort of fit in this bucket, but you need to have a visa to come here. Now, sometimes there are already, and this is not my specific area, but there are already agreements, there are treaties, and also some other things that are in place or whatever, where you don't necessarily need to go to the US Embassy or to the US Consulate to obtain a visa before you come here. You've already got authorization, but you need to make sure that you're here and for what you're doing, and that you're allowed to do what you're going to do when you're here. So what does that mean? So that means, you may or may not be able to come to the US on a tourist visa and do work, right? You want to make sure that you've got the right kind of visa so that this works. So you got to talk to immigration about that. But some of the things, and then there's also an intersection in tax where there's tax specialists who deal with this. But the things that typically come up are just understanding the length of time you're going to be in the US, the amount of time that you're going to have before you need the visa. So what I mean by that is, if you're going to come here for 30 days, you might be able to just rely on a visa, and you might not even need to go out to the US consulate to obtain it, right? There's already an agreement in place with the US and the other country that, you don't need to obtain this visa. But if the US policy is that you don't need to go get to the consulate to get it. But if you're going to be here for a year, you may have to go and get a different visa in order to make that do this, especially if you're going to work. And one of the things that also comes up is, what are you targeting? Okay, is it really just to come here for a certain period of time, or is there are you really working on becoming or permanently moving here? That's interesting. So, not everything. Well, and then I guess the other thing too is, are you going to be bringing a spouse or significant other? And is it important to you whether or not they've got the right to work? So, for example, there are different kinds. Like a B1 might get you 6 months, let's say. But the processing time for that, I believe, can be a couple days to several months. An O1, for example, processing time, and again, I'm not an immigration attorney, so I'm just giving you some information that I've seen in the past. I don't know if it's still accurate or not, but might be 15 to 90 days. That would get, that's for individuals with extraordinary ability. You might be eligible for this if you've sort of raised funding through an accelerator here in the US, right? Some big ones include Y Combinator, Techstars. You'll be able to, I think, stay here for like 3 years ahead of time. You can look these sorts of things up yourselves, but I'm just trying to give you a little bit of a flavor of, there's an alphabet soup of options. You need to be thinking ahead. Well, if I'm going to come to the US, to go to an accelerator, or I'm going to come to, or I want to be routinely come to the US, or I want to come to the US and I want to stay in the US, I want to work. Immigration is an important issue. And I need to think about the length of time I'm going to be here. Okay. So, right. Is that going to be through the whole startup life cycle? Am I going to stay here sort of indefinitely? The amount of time that I have to get this visa, so because these things don't change overnight, and the pandemic has not sped things up. And, am I going to try to bring someone here, my family with me, and do I want my spouse to be able to work? So let's talk a little bit about another thing that's really important on the sort of day-to-day operations for startups that come here to the US, right? So let me give you a little bit of overview of the employment laws here. Like so many other things, the way the here, like so many other things here in the US, the way the legal system works is that you've got federal laws. So that's the US government, the United States government. And then each state's got their own laws. And as a result, there's a lot of overlapping employment regulations. So there are wage, both at the federal level and then each state level, and then sometimes even at the local level, the minimum wage gets set, whether or not, someone's entitled to overtime based on the number of hours they work gets set by each of those. And usually it's the federal government that sort of sets the floor, sets the bare minimum wage that you have to pay and the bare number of hours issues. But you got to follow that. And then another thing that comes up that companies, whether they're domestic or they're internationally based, is just classifying people as contractors as opposed to employees. So employees here in the US, especially, they get treated differently on a number of situations. One is as a matter of employment law. So there's a lot of these wage and hour issues type things, and the duties that you sort of owe to them as an employer. Another is a tax, and we'll kind of talk about that probably in a moment, or that dovetails into there. But if it's an employee, then the employer has the duty to withhold tax on that person's paycheck. If that person is a contractor, then by and large, most of the time, there is no required withholding. So what can happen in this situation is a company improperly classifies somebody as a contractor, does not withhold the tax to the federal government and to the state government, and maybe even to the sort of local government, like the municipality. And then the feds or the state or the municipality kind of goes after that contractor and says, well, pay us the tax this year. You didn't pay us any tax. And the contractor points the finger at the employer and says, well, they listed me as a contractor, but really I was an employee. And there are a number of different tests that sort of apply for whether or not somebody is an employee, but it kind of comes down in large measure to, who controls the way this person works and operates. Are they working for others, or are they basically working full time for you? Is it the type of industry where people work full time for one employer, or is it a type of industry where there's just a lot of different consultants out there, right? Like usually, right, if you're going to engage with an attorney at a law firm or even somebody who's solo, it's very typical and common for that attorney to, they're basically a contractor, right? It's standard for them to work for a number of different clients. They control the hours in which they work, even if, some weeks they may work 80 hours on your matter. And then, sorry, I just got a question, which I'll answer in a minute. Unemployment insurance collection for employees, but not for contractors. Same thing with disability and parental leave. Those are some of the other ways that employees get treated differently than contractors. We've got a question asking, do you use the IRS test for contractor versus employee, or do you use AB5, which is stricter? And the answer is, you got to figure out which government entity is, interested in determining whether or not that person is a contractor or an employee. And that's the test that you use. So on any given person, a number of different tests may apply depending on which government entity is trying to figure out if they're an employee. The other really important thing, whether you're a domestic company or you're, an overseas company doing business here, again, IP, tying in the IP. So, what we see and do here, one of the things we do is make sure that all of the US service providers especially if they're touching or developing IP, enter into agreements that have IP assignment provisions and confidentiality provisions in there to protect the IP and confidential information. The other sort of item that pops up is just equity awards. So, that is getting stock options, and, that touches on a host of levels, but, by and large, you want to make sure you've got the right equity awards set up for your people. That way they can get interest in the company. I'm going to pause there, see if we've got any other questions before we move on. All right. Well, we're moving quickly today. Again, today is really sort of focused on giving you a high level sense for all the areas that you need to be mindful of if you're interested in relocating your international startup to the US. So these are sort of the buckets of things that you need to run to ground. So some of the areas and pitfalls that people kind of get caught on are export control laws. So export control laws here in the US are laws that are focused on, making sure that sensitive technology that is developed, here in the US or with our allies stays within the, US or the allies area. And, in tech, it actually comes up, it's super obvious in a sense if you were developing weapons technology right here, that you would think, oh, I wonder if that's sort of protected, we couldn't export it, right? But there's a lot of technology that's sort of dual use. That is, it can get used, both from a civilian application and military application. That comes up from everything from, at the time, certain types of materials, right? Things that would provide ballistic or maybe radiation resistance to, night vision or, those types of sensor technologies, to stuff in the biological arena, things that could be sort of weapons grade or could be used in the manufacture of weapons, bio weapons or chemical weapons. Things like AI can also be, the government is also pretty focused on that too. So, that sort of coupled with in the last 3 years, sort of changes to the Committee on Foreign Investment in the United States, also known as CFIUS, which, is also focused on, protecting sensitive technology and ensuring, I guess, continuity of sort of basic goods and services and other things in the US, right? So believe it or not, even items that are sort of touching on logistics kind of have started to fall under CFIUS's purview. So that just deals with, if there were to be a foreign investor in a US entity, what type of information are they receiving and do they have control over it? And that can even include sort of, as I understand it, certain types of information that the company might be pertinent to, or certain rights they might have. So, it's my understanding sort of real estate that is next to certain types of ports, whether airports or seaports or other things like that, critical infrastructure, are potentially subject to the CFIUS review. And CFIUS review, again, it's a multi-agency committee that reviews these deals, and doesn't mean you have to do it for every investment in a US company. I mean, again, there are thresholds here, but it certainly needs to be on your radar. One of the other things that pops up are just, if you're here in the US and you're negotiating terms or documentation for venture-backed company, thinking there are like standard terms, like there's just one form of convertible note, or even one form of safe if you're sort of in the seed stage realm. That's not true. I mean, there's sort of a spectrum, and certain things the spectrum is smaller and more narrow, but other things, everything is, other areas, there's a lot of room for negotiation. certainly when we're talking about a true venture capital financing, there's a lot of variation, especially if business is, if the underlying business warrants it. I think that's what I had to say about that. One of the really large pitfalls are thinking that the laws in the United States and the states within the United States are similar to sort of your country. And this flows both ways. So, I'm always very mindful when we work with international companies that, look, just because I know US law and how we'd handle it here does not mean at all that that is the way that is handled in that foreign country. So that is, I think the sort of real takeaway there is that, laws are by and large cultural, sort of formalizing certain forms of culture and expectations, just as, deal docs are also sort of a form of documenting, a business relationship, which is kind of a subsection of culture. And so that's why these things can be drastically different depending upon where you are in the world, where you are doing business. Now, tax and accounting issues, we've sort of talked about a number of these already, but the bottom line is there are a lot of sophisticated tax issues as it relates to doing international business. Now, it doesn't mean that you're going to get treated the way, or you should be treated the way Apple is kind of currently today, where they got teams of lawyers and taxes folks and accountants working on it. But it does mean that you need to be mindful that if you're trying to develop a company that is investable, that these issues are out there. And when you work on this and you're thinking ahead, because that's what you should be doing, and you're thinking ahead towards that exit, right? Because if you're going to be raising venture capital, they're probably looking for about a 7-year horizon on, investment horizon. You need to make sure that you're hooked up with the right advisors, both on the tax and the legal side, to shepherd you through these issues so that you can, put together a company that is investable and that can grow and scale. And I guess actually kind of with that, I've moved through the bulk of my presentation. Happy to answer any questions you have or revisit maybe some of the things that we talked about already. Please use the Q&A function. Thank you. Well, maybe I will move back and I will talk about a couple things that are, oh, that's not moving up there. Let's try that. There's something I want to talk about on IP. So let's talk a little bit more about IP. As I started to talk about. So patents here in the US, they get protected when you file with the USPTO. What you're going to want to do is work with a patent attorney. That's a specialized area. But in the US, it's expensive to do patents, and you want them to obviously extend throughout the US, or excuse me, throughout the rest of the world. The general process here is, you don't necessarily have to go to the full-blown patent application right off the bat, which is very expensive. One of the strategies that startups do is that they will work with a patent attorney to put together a provisional patent. That is sort of a much lighter filing, far less expensive. It basically buys you an extra year or so, I think, to work on commercializing your IP prior to coming to the US, or excuse me, prior to having to file a full-blown patent application. So that can buy you some time, save you some money, and you can kind of use that as your patent strategy in whether or not you're going to try and develop that IP, whether or not it makes sense to actually develop that full-blown application. Trademarks, as I mentioned before, one of the things that you can do is so they're developed, and that's not the right way I want to phrase it. You acquire rights to them in 3 ways. One, if you just, put a good or service into the stream of commerce, you get common law trademark rights in the geography in which you are doing business or selling your products and the time of which you're doing that. That's not necessarily the best insofar as, if you're only selling product in California, but eventually you want to start selling product in Massachusetts, then you don't want someone else selling a similar product in Massachusetts under that name while you're out here in California. So the way to sort of fix that problem is to file with the US Patent and Trademark Office to acquire rights to that particular kind of trademark. You can also secure it on a state-by-state basis, but most of the time people don't do that. They don't file with each individual state to get trademark rights. It's usually done on the federal level. That's something to do kind of early on. Copyrights, again, you can file or not file. Many times, especially in the software arena, the copyrights aren't filed sort of right away, but you do want to, if there's a dispute, you think someone has infringed upon your copyrights, you're going to end up filing to sort of ripen that and make sure that you can go into court to protect it. Again, trade secrets, you need to take steps to preserve the confidential information, the confidentiality of that information. So when I say that, that's what drives, this proprietary invention and assignment agreements, making sure that you get NDAs in place with vendors and other folks kind of before and during doing business with them. That's how you protect your IP here in the US. I guess someone's asking a question, if they publish a scientific article, do they get the IP on that article? Probably not going to have patent right, probably not going to have a trade secret right. Will they have some IP on the article itself? Maybe, but it depends on, whatever agreement they have in place with the publisher, right? As to who's got the rights to that. And, if they publish an IP, if you publish an article, what's in the article is no longer secret. So many times, if you're going to publish an article and it's going to be sort of patented about, it's eligible to be patented, you will take the steps to secure that IP before publishing. That's what we sort of typically see. Now, let me also just kind of back up and say who's in the room here. We've got 16% from the Bay Area, another 13% from California, another 20% in the US. So 50% of the people in the US, another 20% in North America, 70%, and then 26% between Europe and Asia, and a few folks in Africa. And it's noon or just about 1:00 p.m. here in the Bay Area. So again, we will send out today's presentation in about a week or so, as long as you've registered. I want to see if there are any other questions. Otherwise, maybe we will just sort of wrap up a little bit early today. I hope this has been helpful. I hope you've been engaged. Thank you. Thank you. Oh, no problem if you join late. Again, so long as you've registered, we'll send it to you later. All right. Well, today's presentation has been okay. We've got a question on work authorization. If you've got a question, please use the Q&A as opposed to the chat box, if that's okay. It's kind of harder for me to monitor, but we did have a question. I'll hang out for another moment or two, see if we can get it come through the Q&A. Is the Biden administration better than the Trump administration for startups? I must confess, I have not done the specific analysis. I will tell you that startups are doing very well right now. There was initially a lot of uncertainty with respect to the pandemic. But since then, sort of venture has been, and the angel investment has been going off the hook. I don't know if it's appropriate to attribute that to Trump or to Biden, or I think by and large, just the pandemic itself, which has been a horrible experience for many, many people. But with respect to accelerating technology and the need for a lot of different technology and the money that's flowing into it, I think that has been accelerated in the pandemic. So startups, I think by and large, are doing well and seem to be continuing to do well. Obviously, it depends on what your particular startup is doing, but in terms of venture having more demand sort of than ever, that is true. How can an international startup founder be qualified to work on their business in the States? Sort of by and large, I'm not sure I'm 100% following this question, but sort of by and large, if you're an international startup founder, you want to be thinking about, and you want to come here to the States and do work, you need to be thinking about tax issues and immigration issues. Do I have the right visa to come here? And if you do, then you can come here and work. And am I going to be subjecting myself to US tax? Probably. And then at sort of the higher level, so the step up from just the internet and the individual founder, you want to be thinking about, what's this business going to be doing in the US? Is this going to be where we're based or headquartered? In which case we're going to be thinking about maybe doing a flip. That is, the US company would be the parent company. Or is the business going to be sort of a sales office? Or are they going to be like a reseller? And those latter two things probably affect what the setup would look like from an entity perspective. I will tell you, unfortunately, I am not up to speed on the International Entrepreneurship Parole Program. So love to talk about it afterwards, see if maybe we have a lot of immigration attorneys here. Maybe that's somebody who can shed some light on that. Oops. All right. Unless there are any other questions, I'm going to sign off. I want to thank each of you for coming today. Yeah, and I appreciate the opportunity to share this information with you. I want to thank Idea to IPO for organizing and coordinating everything. And I guess one last question, which is, how does the US branch office in an international company affect IP laws? I think, as I mentioned before, you just want to make sure that the international company, or you want to make sure that if you're looking at these international organizations, the IP is flowing and moving correctly between the different entities. That's going to get you the best result. So again, thank you very much for coming today. I'm Jason Putnam Gordon with Polsinelli. Thank you, Idea to IPO, for organizing. If you have any questions, again, feel free to contact me. I do keep office hours. Again, what we talk about, is going to be general information until we get engaged. And I also don't want any confidential information until that point. But I hope this has been helpful. I hope you have a great day. Take care. Bye-bye.